everyone. I'm Maggie McGrath, senior editor at Forbes. The Trump administration has proposed new rules around public service loan forgiveness that could ultimately limit the number of people who access this type of loan forgiveness. Joining us now is Adam Minsky. He is a Forbes senior contributor and a lawyer who focuses on student loans, and he's been covering this issue for Forbes.com. Adam, thank you so much for joining us.
Thanks for having me on, Maggie.
So you have an article out basically breaking down the proposed changes to the federal public service loan forgiveness program. Can you start off by telling us what is the Trump administration proposing here?
Yeah, so basically, public service loan forgiveness is a federal student loan program designed to forgive the debt for borrowers who commit to working for 10 years or longer in nonprofit or government fields. It's designed to incentivize work in those types of settings. What the proposed new regulations do is it would allow the Department of Education to cut off from the PSLF program employers that engage in what the administration deems to be substantial illegal activity. And essentially would give the Department of Education power to eliminate from eligibility entire organizations, including potentially state and local governments, as well as academic institutions and other nonprofits, if they run afoul of these proposed new rules.
Now, you say substantial illegal activity or substantial illegal purpose. And when I hear that phrase, I tend to think of something like drug trafficking and felonies. And in reading your piece, it seems to me that the Trump administration is not necessarily referring to things that classically fall under illegal activity. Can you break down what the administration is defining as illegal in these cases?
Yeah, so it certainly is not necessarily what you might think. So according to these rules, which are intended to implement an earlier executive order that President Trump signed back in March, there are several categories of activities that the Department of Ed would consider to potentially fall into this sort of umbrella of having a substantial legal purpose. This includes providing certain types of healthcare services to transgender youth, facilitating the violation of federal immigration laws, engaging in activities that facilitate illegal discrimination, and violating state law. Now, that might sound to some extent, reasonable or not reasonable, depending on your perspective, but critics argue that this essentially gives the Department of Education power to cut off from eligibility organizations that just don't have the same mission or policy perspective as the Trump administration does. So, for instance, there's some concern that they would cut off entire states or cities led by Democrats if they aren't adequately cooperating with federal immigration enforcement, just as an example.
I was going to ask, does this effectively weaponize, potentially, because this is just proposed changes, these are not officially in effect, but does this potentially weaponize the public service loan forgiveness program for the Trump administration's political aims?
That is exactly what critics of the proposed rules are suggesting it would do. It would give the federal government power to wield PSLF as a tool to force policy concessions from states, from cities, from nonprofit organizations, including academic institutions or hospitals. It would punish borrowers who are stuck in the middle. So for instance, if the Trump administration wants to cut off the entire state government of California or New York from being eligible for PSLF because, for instance, they're not cooperating with immigration enforcement to the level that the Trump administration would like, every employee of the state in that example could be cut off from PSLF.
Now, you get into the history of public student loan forgiveness, and I'd love to bring some of that to our audience right now. How long has it existed? Has it enjoyed bipartisan support? And how often is the program changed by an administration?
Yeah, so the program was created in 2007. It was signed into law. It was created by Congress and signed into law by President George W. Bush. So it was a bipartisan program. It sort of, didn't go through many changes for a long period of time, in part because it took a while for people to reach the 10-year threshold. Then we found out that there were some problems with the program, including counting people's payments or telling people about the rules about how the program worked. So approval rates were pretty low. Under the Biden Harris administration, some new initiatives were put into place, some temporary waiver programs, new regulations designed to make it easier for people to navigate the program. And that resulted in a big jump in approval. So we went from just basically a few thousand people who had been approved as of 2020. By the end of 2024, we had more than 1 million borrowers who had been approved for PSLF.
And these are borrowers who have potentially graduate degrees in law or medicine and have gone on to work for a nonprofit. Is that correct?
Nonprofit or government. I mean, the program is designed, with an intention to give people a pathway to working in fields that traditionally require advanced degrees, but don't pay anywhere nearly as much as what you might receive in the private sector. So a great example of this are prosecutors and public defenders. Who often work directly for state government. They're the folks that operate our criminal justice system. These types of attorneys often take out, $200,000 or more in student debt to be able to get their law degree. But instead of making $250,000 a year working for big law as an associate, they instead are going to take a salary of, say, $60,000 a year working as a prosecutor or a defender. And the only way that they can make this work is through a program like public service loan forgiveness.
Now, under the administration's proposed changes, what would happen to borrowers who are currently enrolled in public service loan forgiveness and are perhaps 5 or 7 years into their repayment plans? They're looking forward to loan forgiveness in 5 to 3 years. Would these proposed changes just end that if their employer is deemed as engaging in substantial illegal activity?
It most certainly could. And in fact, borrowers under these proposed rules would have no recourse whatsoever to contest a decision that their employer no longer qualifies. And the Department of Education's position is, well, these folks can just find a different job. And of course, that is potentially harder than it might seem from the Department of Ed statement on that. But it could absolutely cut people off from student loan forgiveness under PSLF. If there's any good news, it's that it wouldn't erase past progress toward loan forgiveness if the employer is deemed to be non-qualifying, but it would halt any future progress once that determination has been made.
And then have you talked to any sources about what it could mean if these rules go into effect for people entering these nonprofit and government jobs in the future? Could we see an effective depression of or suppression of people working in these jobs?
There is concern that this would have a chilling effect on public service work in general. If you can't know with confidence that the job that you are, trying to get or applying for is going to, result in you getting the benefit that you're being promised, why would people take the risk? Why would people jump into that field if it can just be taken away? That is the concern that some critics have raised, is that this will essentially have a broad chilling effect on employment in, state government, local government, nonprofits, where we really need good people to be taking these roles.
So what happens next? And are these proposed laws or changes rather within the boundary of the law? Because obviously there are a lot of regulations that control the federal student loan portfolio. Is what the Trump administration proposing here even legal?
It's a great question that remains to be seen. There's a process that the Department of Ed must go through to create new regulations. It's called negotiated rulemaking. And there were a series of rulemaking hearings that occurred earlier this year, and certainly at least one committee member argued that this is not legal. Basically, Congress passed a law to create PSLF. It said in the law that if you're a 501c3 nonprofit organization, it qualifies for PSLF. If you're a government, state, local, federal, county, tribal, it qualifies for PSLF. There's no room for picking and choosing which of those employers qualify. Under the language of the statute, those employers are eligible for PSLF. And critics argue that by allowing the Department of Ed to basically pick and choose which of those nonprofits, which of those governments actually qualify based on activities, it may violate the original statute that created PSLF. Some critics have gone even further and said that it could be, some form of viewpoint discrimination if it gets to that point where it could, potentially raise constitutional concerns as well. But like you said, these rules are not finalized; they're not in effect. What happened is the Department of Ed released these proposed regulations following these committee hearings. There's now a 30-day period open to public comment. And then after that, the Department of Ed will publish final rules, probably sometime this fall. And the anticipated effective date when the rules would actually go into effect would be 1st, 2026. Many observers do expect there to be legal challenges once the rules actually go into effect. So it's probably going to come down to a court to figure out whether this is legal or not.
Which, of course, could create confusion for borrowers. What is your message for any borrower who is currently enrolled in this program, who is watching and concerned about their future?
Yeah, I mean, I think, having some level of concern is warranted. I don't think it's time to panic. I don't think this is a reason not to pursue PSLF, which can really be a very beneficial program. But what I'm advising my clients and my readers to do is buckle up for some uncertainty and volatility over the course of the next couple years at least, because we don't know, exactly what's going to happen here. Assuming these rules do go into effect on July 1st, and there are legal challenges, we're still not going to have a clear answer, probably for a little while, as things play out in the courts. So, again, not a reason to panic, not a reason to pull away from public service work, but a reason to be vigilant and keep your ear to the ground about these changes.
Keep your ear to the ground and read Adam Minsky on Forbes.com. Adam, thank you so much for joining us and breaking this down for us. We so appreciate your insight.
Thanks for having me. I appreciate it.